Mr. Noe, are you ready to proceed with Ms. Osorio?
I certainly am.
This is file 25-22362-FH, People of the State of Michigan versus Janeth Osorio. We are here today for a final pretrial conference in this case, and we are proceeding today by video conference. First, can I have the attorneys place their appearances on the record, beginning with Mr. Bayonetto. Mr. Bayonetto, are you there?
I don't believe he's logged in at the moment, but I can appear on his behalf. Isaac Sneed on behalf of the people.
All right.
Good morning, Charles Noe appearing on behalf of and with Ms. Osorio.
All right, and Mr. Noe, where do we stand with Ms. Osorio's case today?
Your Honor, and on this matter, I've spoken with Mr. Bayonetto. We have come to a resolution on this matter. In this matter, my client will be pleading no contest. And for the court's information, the no contest is based on civil liability. Matter of fact, my client has already gotten letters from the complainant's counsel that they're pursuing a cause of action. So therefore, we are going with a no contest plea to an added count 2 assault and battery, and that I believe is the resolution.
All right, Mr. Sneed, is that a complete and accurate statement of the plea agreement?
One additional term, I believe, was a sentence agreement of 93 days of jail to be imposed upon a violation of probation.
Is that accurate, Mr. Noe?
Yes, that is accurate. That's correct.
All right. Ms. Osorio, would you raise your right hand, please? Do you swear or affirm to tell the truth, the whole truth, and nothing but the truth under penalty for perjury?
Yes.
I need you to speak a little louder than that, please.
Yes.
Okay, you can put your hand down. You are Janeth Osorio?
Yes. Yes, Your Honor.
Ms. Osorio, you've heard the statement of your attorney and the prosecuting attorney. Is it your intention to plead no contest today to count 2, assault or assault and battery?
Yes, Your Honor.
I'm sorry, Mr. Noe, we're not able to clearly hear Ms. Osorio. I don't know if it's an issue with your microphone, but it's garbled and unintelligible.
Oh, maybe.
It is. Ms. Osorio is English as a second language, so sometimes understanding her, especially on Zoom, can be complicated. So yes, is that your intention, Janice?
Yes. Yes.
Ms. Osorio, do you understand that the maximum possible penalty for this offense is up to 93 days in jail and or a $500 fine?
Yes.
I just need you to speak louder. If you have to yell, then yell, but I'm having trouble hearing you.
Okay. Yes. I'm sorry. Sorry.
All right. Are you satisfied with Mr. Noe and the advice that he's given you?
Yes, I am.
Neither the prosecutor, defendant, or anyone acting on the defendant's behalf has discussed a possible sentence with the court other than as we've discussed it on the record today. Is that correct, Mr. Sneed?
Yes.
Mr. Noe,
Yes, Your Honor.
is that also your understanding, Ms. Osorio?
Yes, Your Honor.
If a guilty plea is accepted, there'll be no trial. That means you'll be giving up the rights that you would have had at trial. I'm going to explain those to you now to make sure that you understand them. You do have the right to a speedy public trial by jury. You could ask for a non-jury trial. And if the prosecutor and the court agreed, you could have a non-jury trial. You have the right to be presumed innocent until proven guilty beyond a reasonable doubt. You have the right to have the prosecuting attorney prove beyond a reasonable doubt that you are guilty, and you do not have to prove anything. You have the right to be present at your trial, to have the witnesses against you appear at your trial, and to ask those witnesses questions. You also have the right to have the court order any witnesses you have for your defense to appear at your trial. You have the right to remain silent during your trial and not have that silence used against you. However, you also have the right to testify at your trial if you wanted to testify. Do you understand, Ms. Osorio, that if your plea is accepted, you may be giving up the right to appeal issues that would otherwise be appealable if you were convicted at a trial?
Yes, Your Honor.
Do you also understand that any appeal from the conviction and sentence pursuant to your plea would be by application for leave to appeal and not by right?
Yes, Your Honor.
If you are not a citizen of the United States of America, conviction of a crime can result in deportation, exclusion from admission to the United States of America, or denial of naturalization. Do you have any questions about any of the rights that I've explained to you?
No.
Do you understand that you're giving those rights up?
Yes, Your Honor.
How do you wish to plead to the charge that on or about June 2nd, 2025, in the city of Adrian, county of Lenawee, state of Michigan, that you did commit the offense of assault or assault and battery?
No, not a contest.
Has anybody made any threats or promises to you to induce you to plead guilty or no contest to that charge?
No, Your Honor.
Do you understand that if I accept your plea, you'll be giving up any and all claims that that plea was given as a result of threats or promises that were not disclosed to the court on the record today, or that it was not your own choice to enter the plea?
Yes, Your Honor.
Is the prosecutor or defense counsel aware of any promises, threats, or inducements other than the plea bargain to induce Ms. Osorio to plead no contest today?
No, Your Honor.
No, Your Honor.
Ms. Osorio, other than as we've discussed it on the record today, has your attorney promised you any particular sentence or estimated what that sentence would be?
No, Your Honor.
If your plea is accepted and you engage in misconduct, the court will not be bound by any sentencing agreement or evaluation. Misconduct includes, but is not limited to, absconding or failing to appear at sentencing, violating bond conditions, violating the terms of any plea or sentence agreement, or otherwise failing to comply with an order of the court pending sentencing. Do you understand that?
Yes, Your Honor.
Is it your own choice to plead no contests today?
Yes, Your Honor.
Mr. Noe, how are we establishing the factual basis?
Either I can or Mr. Sneed. Makes no difference to me. Mr. Sneed, would you prefer to do it, or do you want to do it?
Feel free. I'm substituting for Mr. Bayanetto.
Oh, sure, that's no problem. Your Honor, a review of the discovery would indicate that on or about June 2nd, 2025, City of Adrian, County of Lenawee, State of Michigan, a Morgan Elizabeth Miller was in the presence of my client, and that Miss Miller did make an allegation that my client did make an unwanted touching of her, in that she did touch her, I believe, upon her chest, and that Miss Miller did not give permission for that touching. Miss Miller also did not want to have that touching occur. This, in terms of a review of police report, on that statement, I believe there is a sufficient factual basis to find a factual basis for an assault or assault and battery upon Miss Miller by Miss Osorio.
Mr. Sneed, are the people satisfied with that as a factual basis?
Yes, I would just add it took place in the city of Adrian, county of Lenawee, state of Michigan on that date.
You agree with that, Mr. Noe?
I do.
Has the court complied with MCR 6.302 B, C, and D, Mr. Sneed?
Yes, thank you, Your Honor.
Mr. Noe?
Yes, Your Honor.
All right, I will accept the plea. It has been given understandably, voluntarily, and accurately. Ms. Osorio has had full knowledge of her rights and she has had competent counsel. The court has not made any agreement regarding the possibility of a plea or sentence in this case with the prosecutor, defense attorney, defendant, or anyone acting in the interest of any of them other than as we discussed it on the record this morning. I will refer this matter to the district court probation office for a pre-sentence investigation and set sentencing for February 27th at 8:15 a.m. Ms. Osorio, you will need to report to the district court probation office that's on the first floor here at the courthouse this coming Tuesday at 8 a.m.
Got that date?
Tuesday.
Tuesday, 8 a.m., first floor of the courthouse. Yep, no, we'll take care of that.
So yeah, this coming Tuesday, January 20th at 8 a.m. All right, anything else we need to address?
On this matter, Your Honor, may my client, myself, appear via Zoom for that sentencing, please?
Yes, that's fine.
Thank you.
All right, anything else we need to address with the case today?
No, Your Honor.
No, thank you.
All right. Thank you for your time.
Thank you.
Okay, Ms. Underwood, are you ready to proceed with Mr. Brown?
Yes, Your Honor, thank you.
This is file 22-20742-FH, People of the State of Michigan versus Bradley Dwayne Brown. We are here today for a pretrial conference in this case. There's also a pending contempt of court for failure to appear. First, can I have the attorneys place their appearances on the record, beginning with Ms. Williams?
Good morning, Your Honor. Assistant Attorney General Carissa Williams on behalf of the people.
Your Honor, Rhonda Underwood on behalf of Mr. Brown this morning, and I apologize for the slight delay. I sent Mr. Brown down to make the payment he was prepared to make today, so we would have proof of that on the record, Your Honor. Mr. Brown has made a payment of $250 today. I have in cash, I have a receipt in my hand, a proof of that. Mr. Brown, I've spoken to the Attorney General's office on this. I believe what we're asking for is a 60-day delay for Mr. Brown to make more payments. I believe he's aware, and my notes reflect that the Attorney General's office wants $250 a month from Mr. Brown, and he's prepared to continue with that, Your Honor. So we would ask for a 2-month adjournment for Mr. Brown to continue payments, and we would be happy to do this to adjourn with Ms. Williams' permission, if the court grants that, Your Honor.
All right, Ms. Williams, is that agreeable with the people?
Yes, Your Honor. No objection to the 60-day adjournment.
All right, I will adjourn this then to March 18th at 8:15 a.m. And Ms. Underwood, if you will prepare that stipulation in order, please.
I will.
Okay, thank you.
Thank you, Your Honor.
Thank you, Your Honor.
Thank you, Your Honor.
All right, thank you. Bye.
All right, are you ready to proceed with Ms. Manson?
I am, Your Honor.
Okay,
All in neat names. I'm not gonna say your.
all right.
I'm not kidding.
This is file 25-22456-FH, People of the State of Michigan versus Kaida Joe Matson. We are here today for a pretrial conference. In this case, it's also set for hearing on a bond violation, alleged bond violation. First, can I have the attorneys place their appearances on the record, beginning with Mr. Sneed?
Isaac Sneed for the people.
And good morning, Your Honor. Joseph Hall appearing for and on behalf of Ms. Kaida Madsen in her absence today, which I can fill the court in more when the court's prepared.
All right, why don't you go ahead and do that?
Thank you, Your Honor. I have been in communication with Mr. Sneed this morning, somewhere in the area of 6 to 6:15 this morning. Ms. Madsen was in communication with my office, stating that she was hospitalized today. We certainly asked for documentation in every instance. What I have as far as that goes is an image sent of a hospital bracelet. I provided that to Mr. Sneed. It bears Ms. Madsen's name and an admission date of 1/14/2026. I have no further information to offer the court as to expected duration of stay, cause for her to be admitted in the first place, or anything else. I have simply an image on my phone. I'm happy to show the court if the court is interested in the same, but that is the extent of the information I have today.
Mr. Sneed, anything you need to address from the people's side?
No, Your Honor, we would defer to the court. Thank you.
All right, I will let you know, Mr. Hall, that yesterday I signed a warrant related to some new allegations of bond violations by Ms. Madsen. She previously had some failure to test issues back in October and November. Also December, she was picked up on a warrant related to those, released her on a bond on December 19th, and on January 2nd, she was apparently tested positive for THC and methamphetamine, and then she missed her January 9th test. So unrelated to any appearance issue today, I have signed a warrant, so she will need to turn herself in on that. And
Thank you very much, Your Honor. I appreciate, obviously I didn't intend to appear in this manner solo today, but I appreciate Your Honor for filling me in on that background information.
so we can get a copy of that warrant for you before you go, if you'd like it.
I would, Your Honor, if possible.
Why don't we set this then for a pretrial on February 4th? at 8:15 a.m. And obviously, I hope she would appear on the warrant before that time.
Your Honor, I can certainly be here at 8:15 as I am here today. I come for, it's about an hour and 10-minute drive. In the event that Miss Mattson is in the wind, as it said, on that date, would your, if she's going to be here, I will be here with bells on, Judge. If she is not going to be here, would the court be okay with me appearing on Zoom?
That would be fine with me. In fact, if you can appear by Zoom either way, as far as I'm concerned.
Okay, thank you, Your Honor. I failed to ask last time, and this morning I was communicating with Mr. Steen about, well, about to drive out there, and we know Kaida's not going to be here, but no way to reach the court at 6:15 in the morning. I couldn't recall on my notes whether there was a specific order that I show up. He didn't have an issue whether I appeared by Zoom, but just in an abundance of caution and making sure that I obey the court's orders, I was certainly going to be here, but I appreciate that from the court.
Okay. Yeah, as long as it's a pretrial conference and, you know, it's not an evidentiary hearing of any kind.
Sure.
I do most of my work by Zoom.
Well, thank you for understanding, Your Honor. I appreciate you once again.
All right, thank you.
I'll stand by for the warrant.
Okay.
All right. Did you make me a file or anything, or a police report or anything?
Yeah, I made up,
Okay.
is
Foster is in lockup down here.
where street?
He's on Zoom.
Mr. Murphy, do you need a breakout session with Mr. Bennett?
If I could, please, Your Honor.
And Ms. Underwood, I have Mr. Dennis is logged into the Zoom session. Do you need to speak to him?
Yes, Your Honor.
All right, Mr. Dennis. Mr. Dennis, if you're there, I'm going to send you a request to start your video. And I'm going to send you a request to unmute your device.
Okay.
Okay, Mr. Dennis, I'm going to put you in a breakout session with Ms. Underwood.
All right, thank you.
Okay, Mr. Glazier. Oh. Mr. Glazer, are you ready to proceed with Ms. Ricker?
I am, Your Honor.
Ms. Ricker? You can go forward and sit here at the table closer to the television. This is file 25-22404-FH, People of the State of Michigan versus Penny Sue Ricker. We are here today for a pretrial conference in this case, a final pretrial conference in this case, and we are proceeding today partially by video conference and partially by in person. First, going to have the attorneys place their appearances on the record, beginning with Mr. Bayanetto.
Alex Bayanetto for the people.
John Glazer on behalf of Miss Ricker.
And Miss, you are Penny Sue Ricker?
Yes.
All right, so Mr. Bayanetto and Mr. Glazer are here by video conference. Ms. Ricker is here in the courtroom. Mr. Glazer, where do we stand with the case today?
Your Honor, Mr. Bayanetto and I just discussed another possible resolution of this case. We'd ask if we could do this final pretrial on Friday at some point, and Miss Ricker can come in and talk to me, and if he can do what we're talking about, he's going to get back with me.
Mr. Bayanetto, is there anything that you need to address from the people's side at this point?
No, Your Honor, Mr. Glazer called me this morning. There is a potential resolution to the case. I'm meeting with the listed victim tomorrow morning, so should have an idea on where we're at with the case in any event. Our trial packet's been filed, our subpoenas have been sent out, so if it does not work, we should be good to go for trial on Tuesday.
I'm not here on Friday, so I can't do anything on Friday.
How about Thursday afternoon?
I'm not here Thursday afternoon either. I'm at a training, a 2-day training.
Judge Anselm may be able to take that plea on Friday.
Yeah, that'd be fine. It wouldn't matter who took the plea, Judge.
Judge,
All
I
right,
did confirm that Judge Anselm is available.
Okay. All right, so what I will do is ask the attorneys to contact the court if a resolution is reached, contact Judge Anselm's court and schedule a time with her to get in front of her and have that plea done.
Understood, Your Honor.
Penny, you need to come in and see me.
Yes.
Penny's there. I can't see her.
Yeah, I'm here.
You need to come in and see me tomorrow afternoon. You'll know by then, right, Alex?
Yeah.
I should, yes.
Yeah, so you come in and see me tomorrow afternoon. Later in
Okay.
the day, say 2 or 3, something like that.
Yeah, I'll stop in your office when I leave here and take that appointment.
All right. Okay, thank you, Your Honor. That's all I had on that one.
All right, we're all set with this case for today. Thank you.
That's it.
Yep. Okay, Mr. Glazer, Mr. Balky, he is not logged in or present here today. Have you had any communication with him?
I haven't, Your Honor. Let me see if I got a phone number for him, though.
All right. Okay, Mr. Murphy, are you ready to proceed with Mr. Brown? I'm sorry, Mr. Bennett.
Yes, Your Honor. Sorry, my volume.
This is file 25-22432-FH, People of the State of Michigan versus Jeffrey Lee Bennett. We are here today for a pretrial conference in this case. There's also a pending contempt of court for violating bond conditions. We are proceeding today by video conference. First, can I have the attorneys place their appearances on the record, beginning with Mr. Bayonetto?
Alex Bayonetto for the people.
Matthew Murphy appearing on behalf of Mr. Bennett.
Mr. Murphy, where do we stand with Mr. Bennett's case today?
Your Honor, Mr. Bennett has a felony pending in district court right now. The next court date for that is the 22nd next week. Depending on what happens with that file, it may change some things with this. So I was going to ask for a short adjournment, just whatever fits the court schedule best past that court date. Just because there's some question marks right now in regards to the thing, we're asking for that if the court wouldn't be opposed to it and if the prosecutor wouldn't object.
Mr. Bayonetto?
No objection, Your Honor.
Is the district court issue related to this file in any way, Mr. Murphy?
It's not related, Your Honor. It's just a matter of trying to figure out if he's going to be held on that file, if they're even going to continue, if there's going to be a plea offer on that one contingent upon him pleading on this file to the OWI third. So that's why we're asking for it. But it's not directly related in any way, shape, or form.
All right, so this file is 90 days since the bind over, and I appreciate a desire to negotiate things, but I can't let cases sit forever. I will grant an adjournment this time. This will be the last adjournment. It will be set for trial at the next pretrial conference if there's not a resolution.
Yes, Your Honor, I understand. Thank you.
So I will adjourn this then to February 18th at 8:15 a.m.
Thank you, Your Honor. My office will prepare a stipulation order for that date and time.
Okay, is there anything else we need to address with this case today?
Not from the
Nothing
people, Your
further
Honor.
from the defense, Your Honor. Thank you.
All right, thank you. Mr. Bennett, you can let the officer with you know that you're done with court for today.
Okay, thank you.
Thank you, Mr. Bennett.
Yep.
Thank you, Your Honor. That's all that I had scheduled. I was going to log off now if that was okay.
Okay. Ms. Underwood, are you ready to proceed with Mr. Dennis?
Yes, Your Honor. Thank you.
This is file 25-22473-FH and 23-21255-FH. People of the State of Michigan versus Brian Matthew Dennis. We are here today for a hearing on a probation violation in the 23 case and a pretrial hearing in the 25 case. First, can I have the attorneys place their appearances on the record, beginning with Mr. Bayanetto.
Alex Bayanetto for the people.
Rhonda Underwood for Mr. Dennis this morning, Your Honor.
All right, and where do we stand with Mr. Dennis's case today?
Your Honor, I think we have the outlines of a plea bargain pretty close. I don't believe Mr. Dennis has signed an advice of rights yet, Your Honor, and he does have a couple things he wants to put in place. So I would ask for a brief adjournment, and at the next adjournment, this case should be resolved.
Mr. Bayanetto, is there anything you need to address from the people's side?
No, Your Honor.
All right, I will adjourn this then to February 4th at 8:15 a.m.
And I will be happy to do the stipulation with Mr. Bayanetto's permission, Your Honor.
Yes, thank you.
So we'll adjourn both files to that date. Is there anything else we need to address with these cases today?
I don't believe so.
No, Your Honor.
All right, so Mr. Dennis, your next date is February 4th at 8:15 a.m.
Okay, thank you very much.
Thank you. You can go ahead and log out. Ms. Underwood, do you need to speak to Jennifer Berger Ellis?
Yes, please, Your Honor.
All right, Ms. Berger, I'm going to put you in a breakout session with Ms. Underwood if you'll give me just a moment. And before I do that, Ms. Berger, you need to unmute your device.
Can you hear me?
Yeah, we can hear you now.
All right. What did I do? What am I doing?
Is there something on your screen asking you to join a breakout room? Mr. Glazer, did you have any luck with Mr. Balky?
Yeah, Your Honor, I got thinking about it and I just faxed over to you. He's in the Jackson County Jail.
Okay.
So it says the custody date was December 20th. I know they were trying to set up a program for him to do, but evidently he's back in jail and I don't know what it's all about, but he is in jail
Okay.
in Jackson County.
Okay, let me call that one then. This is file 25-22396-FH. People of the State of Michigan versus Derek Mitchell Walkie. We are here today for a pretrial conference in that case, and we are proceeding today by video conference. The courtroom is also open to the public. First, can I have the attorneys place their appearances on the record, beginning with Mr. Sneed.
Isaac Sneed for the people.
John Glazier on behalf of Mr. Balky.
All right, and Mr. Glazier, you had indicated off the record that Mr. Balky is currently at the Jackson County Jail. Is that correct?
Yes, Your Honor. We sent you over, we faxed over to you a copy of the notice or the thing we just got off the internet. And it says he's in Jackson County Jail. The booking date was December 19th and reporting agency. So that's where he's at. If you want to adjourn this out a ways, we'll attempt to get a Zoom with him and see what's going on in Jackson. When I said I hadn't heard from him, I forgot. I think I did talk to him. And I think we were working out something about how the Jackson program would satisfy an Adrian program or something along that lines. But evidently, unless he's at the program and this jail thing would be indicating he's at a program, but we'll have to find out. It says he's in jail.
Okay, so I will adjourn this then to February 4th at 8:15 a.m. And we will contact the jail also and see if they can have him zoom in on that date.
Yeah, I don't know if he's going to be in there that long. I have no idea.
Okay. All right, so February 4th at 8:15, Mr. Glazier, would you do that stipulation in order to adjourn?
Yes, Your Honor.
Okay, anything else we need to address with the case today then?
No, Your Honor.
No, thank you.
Okay, thank you. Then we're all set on this one.
I think that's all I have with you, Your Honor. Thank you.
Okay, thank you, Mr. Glazier. And Ms. Underwood, are you ready to proceed with Jennifer Berger?
Your Honor, could I just talk to Mr. Moore for a second?
Yeah, 1 second. All right, Ms. Underwood, are you ready to proceed?
Yes, Your Honor. Mr. Moore has confirmed that.
You've got to let me call the case, Ms. Underwood. This is file 24-22060-FH, People of the State of Michigan versus Jennifer Marie Berger. We are here today for a hearing on a probation violation, and we're proceeding by video conference. Ms. Underwood, would you place your appearance on the record, please?
Rhonda Underwood for Ms. Berger this morning, Your Honor. And I have confirmed, and Mr. Moore has confirmed that the underlying matter was dismissed, Your Honor. And under those circumstances, I believe the probation department wishes to dismiss this as well.
Is that accurate, Mr. Moore?
Yes, Your Honor. The case in district court was no lead on December 29th.
All right, if that's the case, then the court will dismiss the pending probation violation in this case.
Thank you, Your Honor.
Thank you.
Thank you.
Thank you. Ms. Berger, you can go ahead and log out.
Thank you.
Ms. Underwood, you need to speak to Mr. Rakes.
Your Honor, Mr. Rakes and I had a long talk yesterday. I think we are almost there, Your Honor. It's kind of like Mr. Dennis. If we could have that date for a last pretrial.
Okay, let me call the cases then. So this is file 24-21776-FH, 24-21777-FH, and 25-22447-FH. All people of the state of Michigan versus Devin Dean Rakes. The 24 cases are set for probation violations. The 25 cases set for a pretrial conference. Ms. Underwood, would you place your, well, I'm sorry, first let me have both attorneys place their appearance on the record, beginning with Mr. Sneed.
Isaac Sneed for the people.
Ron Underwood for Mr. Rakes this morning, Your Honor. We would
And sir, you are Devin Dean Rakes, is that correct?
Yes.
All right, Ms. Underwood.
We would just ask for a brief adjournment to see if we can get all the i's dotted and t's crossed on this, Your Honor. I believe February 4th would be good if the court still has availability on that date.
Mr. Sneed, is there anything we need to address from the people's side?
No, thank you. I have no objection to the adjournment.
All right, so I'll adjourn this then to February 4th at 8:15 a.m.
And we will be happy to do this stip in order with Mr. Sneed's permission.
Thank you.
Mr. Rakes, you can let the officer with you know that you're done with court for today.
All right.
Okay, this is file 25-22413-FH, People of the State of Michigan versus Robert James Morgan. We are here today for a pretrial conference. We are proceeding today by video conference. The courtroom is also open to the public. First, can I have the attorneys place their appearances on the record, beginning with Mr. Sneed?
Isaac Sneed for the people.
Ron Underwood for Mr. Morgan this morning, Your Honor.
All right, and this is a MDOC case. I don't have any MDOC facility logged into the Zoom session, and they're not present here with him in person. Ms. Underwood, have you had any communication with Mr. Morgan at all?
I have tried, Your Honor. I have not been successful in having them place a telephone call through to him.
All right. What I'm going to do is adjourn this to February 11th at 8:15 a.m. And given the difficulties we've had with communication, I'm going to require that to be an in-person hearing with respect to Mr. Morgan. So Mr. Sneed, would you have the prosecutor's office do an in-person written for him on that day?
Yes, Your Honor.
And I will prepare the stipulation and order. Or is this a court order, Your Honor?
If you would prepare that stipulation and order, I would appreciate it.
Thank you, Your Honor.
Oh, yeah, I'm sorry. We also, looks like we need prints in this case, so I'm gonna do an order for fingerprints. And hopefully we'll be able to get that taken care of, on that same date while he's here in person.
Thank you, Your Honor.
Okay, thank you. I think we're all set with that one. This is file 25-22483-FH, People of the State of Michigan versus Isaiah Marcus Wilder. We are here today for a pretrial conference in this case. We are proceeding today by video conference and the courtroom is open to the public. Can I have the attorneys place their appearances on the record, please?
Isaac Sneed for the people.
Rhonda Underwood for Mr. Wilder today, Your Honor.
All right, and as with the last one, we don't have any MDOC facility logged in and they are not here in person with Mr. Wilder. Ms. Underwood, have you had any communications with Mr. Wilder?
I have not been able to get communication with him at this point, Your Honor, recently.
All right, Mr. Sneed, anything we need to address from the people's side?
No, thank you.
All right, so I will adjourn this then to February 11th at 8:15 a.m. And we will do an in-person writ for Mr. Wilder. We also need fingerprints for Mr. Wilder, so I'll do an order for fingerprints as well. Mr. Sneed, if the prosecutor's office could do an in-person writ, I would appreciate that.
Thank you.
We will, thank you.
And Ms. Underwood, can your office prepare the stipulation and order for adjournment?
We will do that.
Okay. Thank you, then. I think we're all set with Mr. Wilder's case for today.
Thank you. I don't believe we have anything else, Your Honor.
I believe you are correct.
Thank you, Your Honor.
Oh, we do have Ms. Edwards at 11 a.m.
Yes, we do.
Okay. All right. I will see you then. Mr. Malero, you're here for Mr. Rohrback.
That's in the affirmative, Your Honor.
Okay. Mr. Fry has some Mr. Rohrback's other cases, so I was waiting for him to get logged in.
Okay, I can wait.
Let me see if I can check Judge Anselm's court and see if he's over there.
So before you get introduced, could we have Bradley Rohrbeck, please, in front of the judge?
Okay, we're
Thank you.
calling
Thank
for
you.
Mr. Rohrback right now. Mr. Fry, Mr. Malero, do you need to speak to him when he gets into a Zoom booth?
I could have a minute to talk to him. Yes, Your Honor.
Yeah, I would like that, Judge. Are we doing a triple breakout?
Yeah, I mean, I'm fine just doing one altogether.
Okay.
This is the, how about if we crack it like your
All right, Mr. Rohrback, I'm going to put you in a breakout session with Mr. Fry and Mr. Malero.
All right. Karen. Karen. I'm in a breakout, but I can't.
What's it?
I can't. I'm in a breakout, but I can't.
Join. See where the,
Yeah. I'm trying to.
oh, it's not letting you do it.
Sorry, I hit the wrong button, Brian.
It's fine. I think we're done.
This is file 25-22356-FH, 25-22357-FH, and 25-22358-FH. People versus Bradley Dale Rohrback. We are here today for pretrial hearings in each of those cases. We are proceeding today by video conference. First, can I have the attorneys place their appearances on the record, beginning with Mr. Bayoneto.
Alex Bayoneto for the people.
Brian Fry appearing for Mr. Rohrbach on the, I think the 5-8 and the 5-6 case.
Actually, I think I have the 5-6 case. Salvatore Malero on behalf of Bradley Rohrbach on the 25-22356 FH case.
All right, and where do we stand with Mr. Rohrbach's cases today?
Your Honor, I think we have a resolution to resolve all files. Mr. Rohrbach would plead no contest to file 2522358 FH. There'd be all supplements, the habituals would be dismissed, all other files would be dismissed. There'd be restitution. He would owe restitution on the dismissed files as well. The basis for the no contest plea would be civil liability.
Okay, there are 2 counts in the 5-8 cases and pleading to both of those.
Yes, Your Honor.
All right, Mr. Bayanetto, is that a complete and accurate statement of the plea agreement?
It is, Your Honor.
Could you call the jail and ask them to take him advice of rights form?
Your Honor, I don't know if Mr. Fry mentioned it, but he's been approved for recovery court as well.
Okay.
That is accurate, Your Honor.
And Judge, on my case, if I may, I don't see where the bench warrant contempt issue is resolved. Has that been resolved, or does that need to be resolved?
Yeah, okay, thank you. Bye.
Sam, he was sentenced on that contempt. He was given 45 days in jail, could be released to inpatient after 14 days. And I did send a packet over to CMH to screen him for services.
Was that on my case or just Brian's case?
I believe it was on the 5-6 case, your case.
Okay, because I don't see that in there. If that happened, I'm certainly okay with it. But.
Yes, that is correct. That all happened back on January 5th.
Okay, then I'm fine, Judge.
All right, and Mr. Rohrbach, we've had someone at the jail bring you an advice of rights form, so take whatever time you need to read that. If you're comfortable with it, please sign it and just let me know when you're done.
All right, I'm doing it right now.
And then over here, telephone number. Write it down. There you go. We got it. Do you want to keep this in here or are you done?
Thank you. Okay, sir.
All right, Mr. Rohrbach, would you raise your right hand? Do you swear or affirm to tell the truth, the whole truth, and nothing but the truth under penalty for perjury?
I do.
And you are Bradley Dale Rohrbach, is that correct?
Yes, sir.
Mr. Rohrbach, you've heard the statements of your attorney and the prosecuting attorney. Is it your intention to plead no contest today to count 1 in file 25-22358-FH, breaking and entering a building with intent?
Yes.
Do you understand the maximum possible penalty for that offense is up to 10 years in prison?
Yes, I do.
Is it also your intention to plead no contest today to count 2 in that file, larceny in a building?
Yes, sir.
Do you understand that the maximum possible punishment for that offense is up to 4 years in prison?
Yes, I do.
Are you satisfied with Mr. Fry and Mr. Malero and the advice that they've given you?
Absolutely, yes, sir.
Neither the prosecutor, defendant, or anyone acting on the defendant's behalf has discussed a possible sentence with the court. Is that correct, Mr. Bayanetto?
Correct, Your Honor.
Mr. Fry?
That's correct, Your Honor.
Mr. Malero?
Yes, Judge.
If a guilty plea is accepted, there'll be no trial. That means you're giving up the rights that you would have had at trial. I'm going to explain those to you now to make sure that you understand them. You do have the right to a speedy public trial by jury. You could ask for a non-jury trial, and if the prosecutor and the court agreed, you could have a non-jury trial. You have the right to be presumed innocent until proven guilty beyond a reasonable doubt. You have the right to have the court prove beyond a reasonable doubt that you are guilty, and you do not have to prove anything. You have the right to be present at your trial and to have the witnesses against you appear at your trial and to ask those witnesses questions. You have the right to have the court order any witnesses you have for your defense to appear at your trial. You have the right to remain silent during your trial and not have that silence used against you. However, you also have the right to testify at your trial if you wanted to testify. Do you understand, Mr. Rohrbach, that if your plea is accepted, you may be giving up the right to appeal issues that would otherwise be appealable if you were convicted at a trial?
I understand.
Do you also understand that any appeal from the conviction and sentence pursuant to your plea would be by application for leave to appeal and not by right?
I understand that, sir.
If you are not a citizen of the United States of America, a conviction of a crime can result in deportation, exclusion from admission to the United States of America, or denial of naturalization. Do you have any questions about any of the rights that I've explained to you?
No, sir, I don't.
Do you understand that you're giving those rights up?
Yes, sir.
How do you wish to plead then to the charge that on or about April 4, 2025, City of Adrian, County of Lenawee, State of Michigan, that you did commit the offense of breaking and entering a building with intent?
Guilty.
That should be no contest,
No
Mr.
contest. Excuse me, it's no contest.
Rohrbach.
Okay, so how do you wish to plead to that charge, Mr. Rohrbach?
No contest.
And how do you wish to plead to the charge that on or about April 4, 2025, again in the City of Adrian, County of Lenawee, State of Michigan, that you did commit the offense of larceny in a building?
Guilty, Your Honor. Guilty, Your Honor.
I believe you want to enter a no contest plea, so you would need to say no contest.
No contest, I'm sorry.
No problem. Has anyone made any threats or promises to you, Mr. Rohrbach, to induce you to plead no contest to those charges?
No, sir.
Do you understand that if I accept your plea, you'll be giving up any and all claims that the plea was given as a result of threats or promises that were not disclosed to the court on the record this morning, or that it was not your own choice to enter the plea?
Yes, yes.
Is the prosecutor or defense counsel aware of any promises, threats, or inducements other than the plea bargain to induce Mr. Rohrbach to plead no contest today?
No, Your Honor.
No, Your Honor.
No, Judge.
Mr. Rohrbach, has your attorney promised you any particular sentence or estimated what your sentence would be?
No. No, sir.
If your plea is accepted and you engage in misconduct, the court is not bound by any sentencing agreement or evaluation. Misconduct includes, but is not limited to, failing to appear at sentencing, violating bond conditions, violating the terms of any plea or sentence agreement, or otherwise failing to comply with an order of the court pending sentencing. Do you understand that?
Yes, sir.
Is it your own choice to plead no contest today?
Yes, sir.
Mr. Fry or Mr. Malero, how are we establishing the factual basis?
I can do it, if you, Your Honor would like.
I would agree with the prosecutor placing it on the record.
All right, go ahead then, Mr. Van.
Your Honor, as it relates to the case in which Mr. Rohrbach has pled no contest to, reading from Adrian Police Department Report 250004688, Your Honor, had this matter have been had this matter proceeded to trial, the people would have proven beyond a reasonable doubt that on or about April 4th, 2025, in the city of Adrian, County of Lenawee, at the Easy Car Wash, Mr. Rohrback did enter a shed that was located on the south side of the business by cutting the padlock that had been utilized to secure that door. While inside the shed, Mr. Rohrback took various tools, propane tanks, things of that nature that were used to run the business. Your Honor, further, actually, Your Honor, I think that does solve the elements for both counts 1 and 2, being that the defendant did enter a shed located at that property, committed larceny while inside that shed.
All right, Mr. Fry, do you agree with that recitation of facts?
Yes, Your Honor. I agree that it meets the burden for the plea.
Has the court complied with MCR 6.302 B, C, and D?
Your Honor, do you want any facts on the record as it relates to the 2 dismissed cases? Even though they're dismissed, Mr. Rohrback has agreed to plead or to be responsible for the restitution connected with those cases. I can put some facts on the record as it relates to those if the court wants.
All right, is the restitution amount agreed upon, or is there a potential?
It is not
issue?
currently agreed upon, Your Honor.
All right, if that's the case, then I think the people should present what facts they have with respect to the restitution issue, and if a hearing becomes necessary on the amount of the restitution, we'll have that.
Thank you, Your Honor. As it relates to the case ending in 5-7, Your Honor, reading from Adrian Police Department Report 25002932. Your Honor, that case involves the Maple Avenue Car Wash. Your Honor, the defendant was observed on video cutting the lock that was affixed to the coin-operated machine that allowed that car wash to operate. Your Honor, because of the damage done to the machine as it relates to the breaking into it, the victim did suffer economic damages, though the extent of those economic damages are not available at this time. Mr. Rohrback, nonetheless, has agreed to be responsible for restitution as it relates to that case. As it relates to case ending in 5-6, Your Honor, in the as it relates to Magic Fountain Auto Wash and Mini Storage in Madison Township, County of Lenawee, Your Honor, on March 6th of 2025, Mr. Rohrback again was caught on video with a female using bolt cutters to cut locks off of the coin machine that was the lock that was affixed to the coin machine that allowed that that car wash to operate, Your Honor. As a result of the lock being cut off and potential damage to the machine, the owner, Darren Shields, did suffer some economic harm. Again, the amount is not readily available at this time. However, Mr. Rohrback, as part of this plea, does agree that he would be responsible for restitution as it relates to that case.
Okay, Mr. Fry, do you agree that Mr. Rohrback has agreed to an amount of restitution, although that amount is not set at this point?
That is correct, Your Honor. As part of the plea agreement, Mr. Rohrback had agreed to pay restitution on those cases, but the exact amount of that restitution is to be determined.
And Mr. Malero, is that accurate with respect to your case as well?
I concur with Mr. Fry.
All right. has the court complied with MCR 6.302 B, C, and D then?
It has, Your Honor.
Yes, Your Honor.
I believe the court is.
I will accept the plea then. It has been given understandably, voluntarily, and accurately. Mr. Rohrback has had full knowledge of his rights and he has had competent counsel. The court has not made any agreement regarding the possibility of a plea or sentence in this case with the prosecutor, defense attorney, defendant, or anyone acting in the interest of any of them. I will refer this matter to the probation department for a pre-sentence investigation and set sentencing for February 27th at 8:15 a.m. Mr. Rohrback, someone from the probation department will be in touch with you to do a pre-sentence investigation interview. When you do that interview, please be truthful about the offenses and about your background.
Yes, sir.
All right. Is there anything else we need to address in these cases today?
No, Your Honor. Thank you.
No, Your Honor. Thank you.
All right, Mr. Rohrback, just make sure you return that signed advice of rights form to the jail staff and they'll send it over here so we can put it in the file.
I did, Your Honor. I did.
Okay, you're all set then. You can let the officer with you know that you're done with work for today.
Okay, thank you, guys. Thank you.
Thank you, Judge.
Thank you.
Have a nice day, Your Honor.
Thank you. You too, Mr. Malero.
Oh. They are. No.
That's the best way to be moved, right?
As long as they're good in public, they can do them well. Yes. 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 Oh, girl, listen, I'm a teenage girl. Wait, tell them. Well, they will entertain. No, he was 7. I know nothing, but I, you know. And she's like 91. I go 88 years old, living in my house, she's still in high school. Exactly. And it's funny, we had that conversation. We're not getting a salad. I go, I'm sure like, we're not terrible. And I go, you're better than that. Yeah, I don't want to always. Yeah. Yeah, I was. It was great though. Yeah, I learned. Like to record, yes, please. Okay. I just asked. Meet you, Dave.
Yes. So there's two notes here. These are just. Yes. Okay, so there's two. Here, right? This is. Take her. Yes, yes, so there's one, yes. You know what? You didn't want it. Okay. Yeah.
I do motions in the midst of hearing that were filed today. Would you like to begin with the judge's activity? Sure, right now. Yep, sure. Hi. Good, how are you? Good. Okay, great, thank you. Oh, yeah, no problem. Thank you. And look at, I'll give her your lip after.
Next time. Okay, cool. Oh, wow. Your video. You just trying to do next.
Yeah.
Oh.
I'll have this back. I know, that's what Here I am. Just making it. No. How about
Here's the same place.
Doesn't she feel
You leave the arena. Almost everything. They have been. Yeah, they haven't been driving. So, yeah. Actually, I would have been. Over almost 100 years. So, yeah, that's probably. Might be winning this one. Weird to see you without I don't know you right now. I don't know who I am now. I think some new guy. What's the hackathon? No, Eric's here.
Yeah.
Get old. Yes, you are. Were they meta glasses? They what? Were they just meta glasses? No, I can't. Jeff knows how to those.
Stop it.
She gave me the answer for that. I may have to go into the just for one of it. I don't know. I think Peter was like something because he was like, Maybe on some of that hard ground, you have to see your brakes. Probably. Yeah, absolutely. That's what I said, that's good stuff. Probably good.
And by the way, I suggest
I suggest my boss. Well, day by day, because if it gets past the 2 weeks, then somebody can do anything.
Yeah.
Like, no, there's-
He's right.
Anybody can go track. But now we have more time, right? And that- that's your email. Listen to them.
Well, outside of the.
Yeah.
Versus opening stations.
There are all five places that are interested now, we're gonna be sending somebody. To the EID XY.
Yeah.
First track you guys done.
That's the one that like, our attorney is reaching out, that's. Yes.
Just the judges.
How's it gonna be working with them to like get our stuff that we need? Oh.
Some sort of output. You know, put into a box, right? Zero or something. What the law? You know, if they're committed to comments.
I mean, I haven't talked to them, but it's been a conversation, and like I said, the broadcast.
It seemed like our attorney reached out to that, to Chris, and the ball is rolling on that, so that means maybe.
The scripts are saying.
Which was incorrect, yeah. Which one is it? I don't know which one. It's one of them. It's 14, yeah.
Sinclair's fully forward, but they. Yeah.
I have no idea. I haven't watched this before since like.
No Laura Emerson, it's Christy Lee. Little Fox Tilly, the trailer broke apart. This is Laura on the air.
Every now and then somebody posts something else. Watch how bad they
Yeah. She's down. Yeah, he's on show. She did all four stations.
She was proud of it.
Her, I think Laura Emerson. No, she didn't do 13.
Oh.
It was one of the first. Weight loss challenge. Kelly.
She was just on last night.
I saw it pop up again last night. I was like, oh.
Like $100,000 a year. So no,
That was what it is. Someone was.
Yes. It's a great deal of money. That's why. And that's a close relationship, her and that middle one or whatever. Oh, I was just listening to her last night. I was sitting there because we had this whole new system. I don't know. And I just went in there because I had some extra moments before I was going on. And Kelly was on with the like 1 minute, 30. And I was like, I give her like, do you give her cues in advance? Yeah. And then they were saying that the audio, the audio is not ready to like press it all the time, so she comes up screaming. And then the anchors, we want to hear them, so they're like.
The only thing you do is if she report it, that's the only way you can control it. So then it's just a nightmare.
I don't know, it's funny too, because Kelly, but I guess the way that. I just use her to show her. We tend to have problems. Yeah. And that was a bad. So. Emily married this local guy.
remember that.
And then that's when she see. Kind of follows. What's happening? And they're both doing like media training for conferences. In this ladies' company. She did like mornings, like the 9 a.m. show with me when I did it, and then she went to the evenings and did like the 5 shows. And then after I was.
Let's replace Chris.
I didn't want to come in after her. But now it's so late. They're never gonna use that many hours. I'm really upset. How did she do it? I was wondering.
You'll notice like basketball games. Watch like 11, those 8 play later that day, and you won't see her down there. They're 2 years.
Yeah, my daughter's age. I was surprised. My daughter used to play basketball, but we were against that. I was just surprised that she didn't, because I didn't know. I was really surprised.
She said something. That's not my problem. Screwing up. But then juniors, I think, or other son, I think it's
I want one, yeah. Good. You can come stay with me.
I don't know what the things are. I want to go someone else. I think this is the first year. We're getting
I did that for 8 years.
Oh, yeah, your apple pie.
That's right.
No, I love it. I don't agree with that. I go to bed at 7. I go to bed at 7 every night.
You're on.
Oh, yeah, I've been doing it for 2 years. I go to bed at 7, I wake up at 3, I get 8 hours of sleep.
I want to eat.
It's like,
Well, my mom can't go to bed at 7. Yeah.
well, if you split up with the thing, you know, dad takes over. I'm sure you're there for 2 minutes. Works for us.
Yeah. I like it. I need to start going to, I was very.
But then when your kids get older, then everything's in the evening.
Oh, I still miss a lot. Like
Oh, yeah.
my middle child.
Yeah.
Yes.
He thought he'd be alive. Does he really? He's like, oh,
a lot of that 9 a.m. shows.
excuse me. Excuse me.
Once in a while, I see you guys.
Every now and then. No, what I did
You got the
They do the talk show.
Okay. That's cool.
Yeah, 113.
She's like, Jen, you're gonna get
10 on CW.
Yeah.
Is that right? 7.5 on one of those. One of the celebrity shows. More simultaneous, is that just on the web?
Just.
Four?
Oh, the four is just on.
Because our four simultaneous. I don't know if anybody wants to know. That's just annoying. There's a football or something on it. That's time to run a four because it's a promise to see that. So we're trying to get those. It's a great station, like 8 years.
Oh, yeah.
Christmas time, USA program, they ran between 5 and 7.
So I
No news, they just ran it, so ran syndicated, I was like, that would be great.
Was that on Christmas Day? 12:80.
33. I
Oh.
don't remember which one.
Bottom number seven. Why did breakfast pass? I know him. There's. Yeah, maybe.
How's that work? So, we ran quite a bit of basketball on Christmas Day. Hey, we lost all the football we had, so many as we get.
Yeah, that's all just. You're welcome.
All right. Circuit Court is in session. The Honorable Michael Little Saber presiding. Thank you. is file 24-21841-FC, People of the State of Michigan versus Dale Warner. We are here today for a final pretrial conference in this case, and we are proceeding today partially in person and partially by Zoom. First, can I have the attorneys place their appearances on the record?
Good morning, Your Honor. Jackie Wise and Dave McCready on behalf of the people.
Good morning, Your Honor. Mary Chartier on behalf of Dale Warner, who is participating via Zoom. Thank you.
And Marissa Vinsky also on behalf of Mr. Warner.
Thank you. And Mr. Warner is here present by Zoom. We have had some discussion, excuse me, in the jury room about some logistical issues. I think the voir dire questions are pretty much resolved at this point. The jury instructions, my understanding is there are a couple of what we think are minor issues, and you're going to be in contact with Sierra on those. Is that accurate?
That's correct, Your Honor.
That's correct, Your Honor.
Okay. Are there any other issues? Well, I'm sorry, I should also say we have a couple of motions that are pending that will be heard on February 6th. Other than that, is there anything that we need to address, or are we ready to proceed to trial?
People are ready to proceed, Your Honor.
Nothing else to address. The defense is ready to proceed to trial. Thank you.
All right, then. We will resume then on January 27th at the start of trial. Thank you for that.
Thank you, Your Honor. Down to your office.
That's right.
See you then.
I'm just here. Yes, sir. Sweet. On the record. Yeah.
Oh, okay. Shocker. Well, she's gotta get them in. Hello. That work?
No.
So what's on the floor?
No.
The dog or?
No, that was short and sweet.
Okay.
Apparently the timetable going forward. Festival itself. Evidence here.
That was the biggest thing we've ever had. Is this on?
So.
What are, do we know what these bullshit motions are? No?
That's normal, that's not.
John, I can't.
I think it's.
The same reason you had your client's ex-wife.
So.
She's gonna try to. You know, I'm a little upset with you, Greg. She doesn't ask you to meet before, so that you know what to expect. I'm upset for you, you know? I know that you're looking forward to that, but I need to ask John at what point, when you're gonna be out, you know, while we came to our side, right, and bullshit out.
So for a normal murder.
I would think they do 50 every time. Are you basically allowed to? Not for June.
So I've been just watch. At least I've never.
Right.
Jersey after they have other couples. Because once the case is over, the jury can talk about it.
Right,
Jury can
right.
talk about it.
But not.
But keep it, I see some people about this. So I don't.
So maybe they don't allow. They're not
So
allowed.
there was the Jimmy Allen. Years ago. And there was some coverage of that. And here's they're shooting over here and just hope don't shoot. And then for verdicts, I was actually there. My camera go. And I didn't, just respected their privacy. So, they don't choose it. Yeah.
No.
I thought this was. The other thing that someone's had to some drugs is so I think that's yeah, especially after that last week. Yeah. So that didn't happen. I no. Yeah.
Clear down.
Okay, good morning. Again, Ron, we're calling for Ms. Edwards right now.
We could cut a reset.
Thank you.
Thank you. Bye.
We're gonna have, he's got a bench warrant. There's someone there on the jail Zoom device. I have sent a request to start the video.
You might get Kelly and JoJo Savers.
Okay, Ms. Underwood, you need to speak to Ms. Edwards.
So if you could log into Zoom for.
I spoke to her yesterday, Your Honor, but just briefly.
Okay.
All right, thank you. Bye.
Good morning. Thanks for coming over.
Judge.
Yeah.
On him, we just received information this week. He was in our program and he was terminated for the program rules violation. So this happened after the warrant was issued for the drug usage.
Were you talking about my client?
Oh, I'm sorry. He was talking about Mr. Skinner.
Oh, okay.
So let me. We're still waiting on, I think Sarah Teskey, who is Ms. Edwards' probation officer, is still in Judge Anzalone's court at the moment. So we can go ahead and do Mr. Skinner first and hopefully let Ms. Teskey when we're finished with that. Do you want to talk to Mr. Skinner first, Ms. Underwood, or well, I guess.
Yes, please.
Okay. Mr. Skinner, are you there?
Can you hear me?
Yeah, okay. Mr. Skinner, I'm going to put you in
I
a
apologize,
breakout.
Judge, for
Mr. Skinner, I'm going to put you in a breakout session with Ms. Underwood.
Yes, sir.
All right, this is file 24-22031-FH and 24-22029-FH. People versus Patrick Lee Skinner. We are here today because Mr. Skinner has logged in. He does have a warrant pending in both of those cases for an alleged probation violation. Ms. Underwood, do you want to place your appearance on the record?
Rhonda do it for Mr. Skinner this morning, Your Honor.
And sir, you are Patrick Lee Skinner?
Yes, sir.
All right, Ms. Underwood, do you know what is it that Mr.
Thank you,
Skinner
Your
would
Honor.
like to do today?
Your Honor, Mr. Skinner has zoomed in this morning in good faith. Mr. Skinner has been involved with the VA trying to get his benefits to get treatment, Your Honor. The VA has now come through. His benefits have now come through. But the VA will not take Mr. Skinner with these warrants out, Your Honor. Mr. Skinner respectfully asked the court to lift the warrants so he can get the VA treatment he badly needs, Your Honor. Mr. Skinner is trying to stay clean, and he's trying to do that, but he wants VA treatment and assistance, and they are ready to go hands-on the minute these warrants are lifted, Your Honor.
Judge, I'd like to add on to that if I can for a minute, 30 seconds.
I don't know if Ms. Underwood wants you to do that. You're represented by an attorney, so she speaks for you.
I've known you for 4 years now. All right, I've been using intravenously methamphetamine for 3 years solid. I'm 13 days clean, first time ever, and I don't want to go back to that ever. All right, jail is not a good place. You know, it's not a good place for that. I am not doing anything wrong. I'm going to Ann Arbor today. If these warrants are lifted, I'm going to make the VA put their money where their mouth is. I should have got these benefits 17 years ago.
Where are you right now, Mr. Skinner?
I am in Jackson. I came back to Jackson because I was going to meet with my PO up here face to face to show her that I am indeed in a far better place than I was the second when I decided I needed help. I did that, Judge. No one told me to do that. I was in treatment for 13 days. I ended up getting the fraternization thing, and I walked straight from the rehab home and new vision over to the VA directly, all the way across Ann Arbor. And the first words out of my mouth is, "I want battle cream." All right, but they want me to turn myself in and sit in jail for 2 weeks and wait for a bed. But they said if these warrants are lifted, it cuts the red tape, and they go hands on, and the rocket lifts off. Judge, I'm not in a good mindset right now. I engaged in the meetings the past 2 weeks. I shared at the NA and AA meetings, and I was sincere about it, you know, and I actually tried instead of just sitting back listening to people, you know, but throwing me in jail, especially after the holidays, man, my son's birthday's coming up in 3 days. I've never even met him.
Well, I appreciate that, Mr. Skinner. The problem is you've lied to me in the past about these same issues. And
Judge, I've always
so,
showed up for you.
Mr. Skinner, Mr. Skinner, don't interrupt me. I've heard you talk a lot. I've heard you tell me a lot of things. I've heard you tell me you're clean when you weren't. I've heard you tell me that you're ready for rehab when clearly you weren't. And so now you're asking me to do the same thing again when you have a pretty significant track record of not doing the things that you've told me you're ready to do. And so it's understandably an incredibly difficult decision for me. The warrant that you're before Mr. Skinner, I'm going to mute your device, and I'm going to ask you not to unmute it until I tell you to. The warrant that you're currently before the court on includes a positive methamphetamine test from back in December. Sir Stevenson, do you have any thoughts you'd like to share on this?
We issued the warrant for the drug usage, and after that warrant came out, he entered a program, he entered the home revision program. This week they contacted me and they advised me that he was terminated from the program. So he was cut loose from the program. We have a warrant out for him. I would like to see him lodged. This is his third violation of probation. We've had continuing issues with him using drugs and not finishing through with treatment.
All right. So I am going to require you, Mr. Skinner, to turn yourself into the Lenawee County Jail on this warrant. I'm not saying I'm going to make you serve a bunch of time on this. If we can verify that you have in fact received your VA services and they are, well, Mr. Skinner is pointing and trying to say something to me, but I've muted his device. As I was trying to say, well, Mr. Skinner has now left the meeting. I assume of his own accord. I will make a record that when I said that he would be required to turn himself in on the warrant, he started speaking, he stood up and walked around, he was pointing at the device in a clearly agitated manner. What I was going to say was that if he were willing to turn himself in on the warrant and we could establish some proof that he had in fact been, Ms. Underwood, please let me make my record.
Your Honor.
Ms. Underwood, please let me make my record.
Yes, I apologize.
I was in the midst of saying that I was trying to advise Mr. Skinner that if he would turn himself in on the warrant and we could establish that he had been approved for VA services and had a bed available for him in the program. I think he referenced Battle Creek. I'm familiar with that, having had some other people go through that. I would have let him do that. But what I wanted from him was to simply turn himself in so that I could be assured that that's where he was going, because he has not been truthful in the past about where he has been and what he has been doing. And I thought that that was necessary to make sure that he got the treatment that he so badly needs. So I will leave the warrants outstanding and we'll deal with Mr. Skinner once he is arrested on those or decides to turn himself in. So Ms. Underwood, what is it you wanted to say?
I apologize, Your Honor. I was just going to say along those lines, if Mr. Skinner turns himself in, we can have Ms. White from our office reach out to Battle Creek as soon as that happens and confirm what he needs to do. We would have no problem doing that, Your Honor. And the court has been very gracious this morning. Thank you very much. And I hope we hear from Mr. Skinner.
I do too. I'm happy to help him get to that program, but I'm not going to take his word for it that he's going to do it voluntarily.
That's understood, Your Honor.
All right. All right. Thank you, Mr. Stevens.
All right.
Thank you.
See if Sarah, we'll call her and see if Ms. Teskey's available.
Hey, Sarah Kelly and Judge O'Savers. We have Kateresa Edwards for hearing at 11 o'clock. Can Judge? All right, thank you. Bye.
She logged in. Is she logged in?
Yes.
This is file 24-21766-FH and 25-22100-FH. People of the state of Michigan versus Kateresa Pearl Edwards. We are here today for a sentencing on a probation violation. We are proceeding today by video conference. Ms. Underwood, would you like to place your appearance on the record?
Rhonda Underwood for Ms. Edwards this morning, Your Honor. Thank you.
And Miss, you are Kateresa Pearl Edwards? So I wasn't able to hear that.
Yes, I am.
Okay. Ms. Edwards, have you received a copy of your probation violation recommendation?
Yes, I have.
Have you had an opportunity to discuss that with Ms. Underwood?
Yes.
Are you satisfied with Ms. Underwood and the advice that she's given you?
Yes, I am.
Do you wish to explain or challenge the accuracy or relevancy of any information that is in your pre-sentence report?
I don't believe we do, Your Honor.
All right, then, Ms. Underwood, is there anything you'd like to say on behalf of Ms. Edwards before the court passes sentence?
Absolutely. Your Honor, first of all, Ms. Edwards understands Ms. Walsh's concerns, and she understands why she was violated, and she is very cognizant that it won't happen again. Ms. Edwards has been clean from meth for a year, Your Honor. She is doing both the substance abuse and the engagement group in jail, Your Honor. I don't recall when I've had someone say the words that they're trying to put their time in jail to good use, but that's what Ms. Edwards relayed to me. Your Honor, I think she can be a successful probationer. I would ask, I know Ms. Teskey has done the recommendation and has recommended 45 days with credit for the time Ms. Edwards has done, which I think is about 15. I would hope the court might consider in this matter putting Ms. Edwards back on probation with time served in this matter. Your Honor, I think she's contemplated and put her time in jail to good use, but now I think it's important to her to follow her probation successfully and do that. So we would ask the court to consider that, Your Honor.
Ms. Edwards, is there anything you'd like to say on your own behalf before the court passes sentence?
No.
So this is a case where Ms. Edwards was placed on probation back in June of 2025. This is a violation for failing to appear on October 21st, 2025, and then failing a contempt of court also for failing to appear at the summons hearing on failure to appear. I would note the probation violation recommendation report is correct that the failure to appear went on for more than 60 days, so it would constitute absconding purposes of determining what the punishment is for the probation violation. I am however, happy to hear that Ms. Edwards you've been dealing with your substance abuse issues, although one of the things about saying you've been clean for a year is that, we need evidence of that, and we don't get to have evidence of that if you're not reporting. Obviously, then you're not taking your tests, and so we don't know. And you're in a situation right now where, I'm not saying I don't trust anybody, but there are situations where I have to verify, and you're in a situation where we have to verify. I think you're also in a situation where, as you've just seen, that I'll trust people, but there are some people that say I'm doing what I need to do because that's what they need to say to get out of jail, and there's some people that are saying I do what I need to do because they mean it. And if I figure out that you're saying it just because you want to get out of jail and that you don't mean it, the consequences from there start to look less attractive. So I will take you at your word this time, Ms. Edwards, and I will reinstate you to probation. It will be the sentence of the court that you serve 15 days in the Lenawee County Jail with credit for 15 days served. And it's my hope that you will go forward with your probation and, do the things that you said you're going to do, that you've got the problem fixed, and you're going to go back to performing well on probation. You will need to report, Ms. Teskey, when will she need to report? Tuesday?
No, Your Honor, I would like her to report to me tomorrow morning at 8 a.m.
Okay, so tomorrow morning, Ms. Edwards, at 8 a.m., you need to report to Ms. Teskey. Sorry,
Thank
I
you.
think you're too far from the microphone. You said something, but I couldn't understand it.
But all right, thank you, Your Honor.
Do
Okay.
we need to send over judgment, Your Honor, or notice of appeal?
Oh, thank you, Ms. Underwood. We'll send over to the jail, Ms. Edwards, 3 copies of a notice of right to appellate review, notice of a right to appellate review and request for appointment of attorney form. You need to sign 1 copy of that and leave it there at the jail. That they'll return it to us. That just means you got your copies of the form. If you wanted to appeal your sentence, you would need to fill out the remaining portion of that form and mail it to the address listed in the form within 42 days.
Okay.
All right, so you are all set for today then.
Thank you. See you in the morning, Ms. Teskey.
Okay, thanks, Judge.
And I'm sorry, I didn't mention the contempt. Sentence on the contempt will be the same, 15 days in the Illinois County Jail with credit for 15 days served. Okay.
Thank you.
So we're all set. Thank you.